Unfortunately, there are only two ways in which a family law dispute can be resolved. The first, and often the best way, is by the parties coming to an agreement in some form. That may take place at a court or after a mediation, or indeed just by negotiation between the parties with or without the assistance of a lawyer or a mediator. The other way is by a court order, and that order having been made by a judge after hearing evidence and coming to a decision based on the judge's determination of the matter pursuant to the Family Law Act. Going to court doesn't necessarily mean that a judge will ultimately decide the issue, but it is the reason one goes to court. Often, court is necessary when the parties are having trouble in coming to an agreement, or when the parties are in a dispute which is impossible to mediate or to resolve, or in circumstances where one party is not complying with the rules, and the use of the court and their capacity to make orders is necessary to bring that party to heel. Importantly, it must be remembered that at any stage of the process, right up until the judge makes a final decision, parties can come to an agreement themselves and therefore make a decision themselves as opposed to a judge. If you are going to court for the first time in your family law matter, it will be a daunting and bewildering experience, even if your lawyer has explained to you what is likely to happen. The court presently is engaged in dealing with a number of matters, and under fairly difficult circumstances, there is a reduced amount of judges available for parties, and therefore there are often long lists and long waiting times. You'll get to court, and if you're not there with your lawyer at the time, there will be a number of people there. There are many people like you waiting to have your matter heard before the court. Hopefully you have arranged with your lawyer where and when to meet, and can take up with your lawyer once you've arrived at court. There will be other court practitioners there, namely the court officers, barristers, solicitors. Sometimes there are court staff there, security staff, and of course a great many other litigants who are having their matters heard in court that day. Generally speaking, you do not have to bring anything with you. Your lawyer should bring all the court documents with them when they come to court. My advice often is to bring a support person. There will be times when you will need to spend alone, when your lawyer is either negotiating with the other party or dealing with other matters. It's always good to have someone there to talk to, someone there to be of assistance, but preferably someone who's going to assist you rather than make decisions for you. There will be times, if we have to spend all day at court, you might need to go off and have lunch alone or breaks alone, and it's good to have someone with you. If you are there in court on a first return date or on an interim hearing, then it's likely that your lawyer will want to engage with the lawyer on the other side, or the other party on the other side, to try and resolve the matter prior to it actually going before the court. Many matters are what's called stood down, which means they are taken out of the list of the matters the judge has to decide to allow the parties to try and resolve it before the court has to. That's the best way of resolving matters, even if you're at court. Oftentimes, when both parties are at court with their lawyers, it's the best time to resolve matters. If you're able to come to an agreement with the other party, your lawyer will probably ask you to sign a document, which might be partly handwritten or partly typewritten, which sets out the orders that you and the other party wish the court to make. If that document is signed, it is often handed up to the court, and the court proceeding then takes a fairly simple and short process. The judge will read the proposed orders, Perhaps ask some questions of the lawyers to make sure that the orders are just and equitable or appropriate if it's a parenting matter, and then make the orders. And then it becomes a quick experience. If the parties are unable to come to a resolution on all of the matters, then there will be a hearing before the court. A hearing before the court generally means that the parties will called up to the bar table. You will sit at a specially designed set of chairs behind your lawyer. They will sit at the bar table, and in front of you, you will see the judge, who's a little higher and wearing a particular judge's robe, and in front of the judge, you will see one of the judge's associates. The lawyers will announce their appearance, they will say their name, in other words, and then the judge will invariably ask a series of questions, and then the lawyers will argue or make submissions about the orders that you and the other party want the court to make. Generally speaking, after those submissions, the court will then make a decision, perhaps handing down some brief reasons why the decision is to be made. Generally speaking, the process between the lawyers and the judge is a legal one, although often facts are necessary to be established in order to make the right order. It is highly unlikely that you will be required to speak directly to the judge. Sometimes judges like to ask parties directly certain questions, but generally they'll ask your lawyer. You will not be required to make submissions yourself unless you don't have a lawyer there with you. If the parties have resolved all matters, often the judge likes to congratulate the parties and speak to them directly about how the orders are going to affect them into the future, particularly with respect to parenting. At the end of the hearing, the court will have made an order one way or the other, even if it's an order to have the matter adjourned to another day. As mentioned previously, you might have signed a document which sets out the orders that you and the other party have agreed that the court will make. Alternatively, the court will have made certain orders. It could be a combination of those two things. Generally speaking, what happens then is that one party is tasked with setting out in writing what those orders are, conferring with the other party to ensure that their recollection is correct, then sending a document to the court for the court to then seal and return to you, which then sets out the orders. It's important to note, however, that the orders are made at court on the day that you attend court. Taking a lawyer to court can be very expensive. If you have carefully understood your costs agreement with your lawyer and talked to the lawyer about costs agreements, you will know that spending time into court can be very costly. But it can also be the best way to resolve matters, and often money spent in court early can mean that money can be saved at a later date. Your lawyer might suggest that you engage the services of a barrister. A barrister is generally a specialist advocate, one who is particularly versed in the ways of the court. Generally speaking, most solicitors will be able to do that job themselves. However, in complicated matters, it is advisable to at least discuss the idea of retaining a barrister, particularly when it comes to having a trial. Sometimes you'll only meet the barrister on the day of court. Generally speaking, that is due to workloads. It's important to ask questions of the barrister, to glean their understanding of the matter, and to understand what they intend to do with your matter once it gets to court. Your barrister, like your solicitor, will want to engage with the other party to try and come to a resolution. If the matter does go before the court, your barrister will make submissions and arguments on your behalf. Barristers can also be very expensive. However, use of them can be very important in making sure you get the right outcomes for your case. Like always, it's important to ask questions. It is critical that you as the client have a full understanding of what is going on in your case, what the strategy is, what the process is by which you are going to court, and why you are there. It's always important at every stage that you ask questions. Often leaving court not knowing what has gone on or what has happened can be very upsetting. That's not the time to ask questions. The time to ask questions is up front when you want to know the information and make sure your lawyer answers them.